they offer me 40 hours of community service. Is that still on the table?
Okay.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
That
Yeah,
may
it says
manufacture.
it says automobile, horse, drawn wagon, or carriage.
Okay.
So
So,
an
Mr.
automobile is not necessarily a car if it's a household good.
But
I
all
mean,
of those things are not
an
true.
automobile was actually created before a driver's license was ever created.
So you're before the court on 2019 CR 04954 for driving on a suspended or revoked license, no license, failure to display license, or failure to have license on person. I'm not sure, it cuts off, and no tag or expired or invalid tag. So that's on the first case. On the case from 2020 03114, you have a suspended or revoked license. You're represented by Lister and Holt on one of the cases, but not on the other. Did you want Lister and Holt to represent you, or did you want to represent yourself
I represent myself.
on both cases?
Yes, ma'am. I have a quick question as far as law term when it comes to driver's license.
Okay.
Okay, you're only allowed to have one driver's license, and
Right.
I have an Alabama driver's license. So when I get pulled over, I actually show them my Alabama driver's license, and it's current. It's the most current, and so they make a determination.
Buckle up, guys, because today we're diving into a courtroom standoff that'll make your jaw drop. It kicks off with the judge addressing what should have been a routine matter, but instead, he gets hit with the classic sovereign citizen curveball. The defendant claims he doesn't recognize the court's authority. You can practically feel the temperature drop as the room braces for chaos. It's not just legal nonsense, it's defiance cloaked in pseudo-legal jargon. And the judge, he's already having none of it.
If they should go off the Georgia driver's license or the Alabama driver's license. And when I present the Alabama driver's license, they let me go because my Alabama license is valid. And you're only allowed to have one. And I had Alabama license first.
Honor,
So
I
my
believe
Georgia
this sounds
driver's
like a not
license.
guilty.
Excuse
Okay.
me?
So, Mr. Resto, what Mr. Taylor is saying is this is something that you could prove at trial. If you present that information at trial, then that means you want to go to trial instead of taking a plea. I don't know what the recommendation is, and I don't
Well,
know.
the recommendation was, I think I've been dealing with this case for an awful long time now. So I
Yeah.
don't really want to go to trial. I just want to get it behind me. But I think that the recommendation, I remember the recommendation quite clear. They offered me 40 hours of community service. Is that still on the table?
Okay, no. So the basic fines and fees for driving on a suspended license is the first time in 5 years. If you get one, then you can enter a NOLO plea if you have a NOLO plea eligible to you, and then the fine is $500. But if you get a second one, the fine goes to $1,000. A third one, the fine goes to $1,500 and 10 days mandatory jail time. You have a second one, which means that you might be able to enter a NOLO to the first one, but then the second one is outstanding. So when you took a plea to the second one.
All right, guys, things start heating up fast. The judge lays down a simple question, but instead of a straight answer, the defendant goes on a rant about being a private citizen and challenges the court's jurisdiction. It's like watching someone bring a spoon to a gunfight. The judge, stone-faced and razor-sharp, sees right through the act. You can tell he's heard this sovereign script before, and he's not giving it any airtime. This isn't a courtroom anymore. It's turning into a showdown.
That would definitely suspend your license. So that's what's on the table.
Okay, now if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay, I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
okay. Well, I asked this question previously when I was in your courtroom one day in regards to the right to travel under the 14th Amendment, stating that citizens do not need a permit to travel with a horse-drawn carriage, wagon, or automobile without interference by police. And I was on a public highway actually when I got pulled over.
okay, so That's not actually in the Constitution.
And
So
I
the
don't
right to
believe
travel, the right
automobiles
to
were
travel.
around when the 14th Amendment was ratified.
I'm sorry. Go ahead, Mr. Taylor.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified. That
Yeah,
may have been a fact.
it says automobile, horse, drawn wagon, or carriage.
Okay, so
An
that's
automobile is not necessarily a car if it's a household good. It's just a form of transportation. It doesn't matter if it's an automobile, horse, drawn wagon, or carriage, because it's still a form of transportation, and citizens have the right to travel without interference by police. So I don't even know how the police are even allowed to interfere with travel when I'm not using my vehicle for commerce.
Your Honor,
And it's
hold
a
on, Mr.
totally
Taylor.
private household.
Here's where the tension climbs another level. The judge warns the defendant, but the man fires back with more pseudo-legal jargon, acting like he's schooling the court. The judge keeps it professional, but you can sense his patience wearing thin. What the defendant doesn't realize? This courtroom isn't a debate stage. It's a legal battleground where theatrics don't win cases. Every word he says is digging a deeper hole, and the judge? He's just letting the rope unravel.
if somebody drove 100 miles an hour into the back of your vehicle and killed your a family member, would you want the police to interfere?
That's a murder. I mean, that's if someone got killed.
But they're traveling. You can't interfere with somebody traveling.
No, I mean you can't. It's stating that a police just can't interfere with your traveling, like pulling you over for a traffic violation or a tag.
But you want them to interfere if
now
somebody.
if you murder somebody because of
Well, okay.
sovereign,
Say you don't murder them. Say you just hurt them. Say you just damaged the vehicle. You don't want the police to interfere.
no, that's when it almost becomes like an accident or a crime or whatnot. So the police can. That's not really an interference. An interference with your traveling, not an interference when two citizens engage in an accident. It's interfering with you just traveling. Now, police officers, as far as public servants, they have a duty to serve to the people. So if a car accident occurs, then of course public servants, as far as ambulance, as far as firemen, they will come to the scene just as a service. But for you to just interfere in my...
Now it's getting uncomfortable. The defendant demands proof of jurisdiction like he's in some TikTok debate room. The judge responds with calm authority, brushing off the antics and steering the court back on track. This moment right here shows the disconnect. One man playing pretend lawyer, the other upholding actual law. It's a textbook example of how sovereign citizens misunderstand the very system they're trying to outsmart. And the judge? He's playing chess while the defendant's stuck on checkers.
Traveling is actually a violation of the Constitution.
Well, sir, the Constitution and the cases that have come out of the constitutional jurisprudence allow cities and states and municipal organizations to regulate travel for the benefit of the citizens. So they can put reasonable regulations on travel, meaning you can have a license. They can grant you the privilege of having a license to drive. They can regulate how your license is seen. If you don't have a license, or if your license is suspended, they can intervene to take your license away or your privilege to drive away. It is a crime. You can be convicted of not driving under a proper license. So the government is allowed to intervene in a lot of ways with people traveling. So I'm not sure where this information comes from, but there's a lot of stuff on the internet about traveling and the 14th Amendment and horse and buggies and even maritime law. But
I mean, an automobile was actually created before a driver's license. There are case pamphlets where people was actually operating vehicles before a driver's license ever became. That's actually, you guys are actually a conflict of interest, actually, as far as you being in cahoots with the DMV. That's a totally separate entity.
Okay,
and for
so
some reason,
Mr. Resto, do you want to resolve the case? Because it's not.
I want to resolve it.
This is where it spirals. The defendant cuts off the judge, interrupts the court, and tries to flip the script, like he's got the upper hand. But the judge finally snaps, back with authority, making it crystal clear who's running the room. No more warnings, no more leniency, just consequences. You can see the shift. The judge isn't just dealing with foolishness now. He's drawing the line. And in that moment, the sovereign citizen fantasy starts crashing hard into legal reality.
40 hours.
I disagree with the fine amount because it changed. I would I would make an offer like I can do $1,000, maybe 12-month probation.
Mr.
But $2,000, that's excessive.
Mr. Resto, we're not negotiating. Those are statutory fines, meaning they're written into the law. I can't even change them.
Can I make a counter offer to the state and say it's $1,000? Can I be?
No,
because I did do time in jail. If the state would see that and count.
That's why I'm saying that you may want to speak with an attorney, because certain things that they can negotiate, I can't change the statute. I can't change what's written in it, but they can negotiate. And if the solicitor wants to give you credit for time in jail in lieu of the fine, those are things that they can do that I can't do.
Yeah. So I would ask to the district attorney, knowing that I did serve some days in jail, can you guys lower the fine and I just go ahead and end this case right now? I can do $1,000. I got $1,000 right now.
Mr. Resto. So that's a conversation that you need to have with them directly without me being present. Number one. Number two, the reason I keep saying you might want to go through your attorney is because they can explain to you what is already on the table and how that may or may not change. Okay.
What's on the table now?
I don't know. That's what I'm saying. I would rather you have that conversation in a breakout room with the.
Things are unraveling fast. The judge lays down a direct order, and instead of compliance, the defendant tries one last dodge, invoking imaginary rights and misquoted laws. But the judge isn't here for fairy tales. His tone turns icy, and you know what's coming. The court's patience has run out. It's not about winning an argument anymore. It's about maintaining order. And as the judge prepares to move forward without him, the defendant's grand act officially collapses into chaos.
Attorney who's assigned to your case and with the state, as opposed to here in the main room. One, because I have other cases that need to be addressed, and two, because that's not information I need to hear.
Okay, is it anything I can do to get this case resolved now? Because it's been lingering on.
I'm telling you what to do, but you're not listening, Mr. Reston. Mr. Resto. I
mean, today, I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me. I said you can go into a breakout room with your attorney, and the attorney and you can discuss what's already on the table. And then if your attorney wishes to speak with the state to clarify anything, they can do that too. But you're not going to get it resolved by going back and forth with me, because there's stuff I cannot do.
Okay. Just tell the state that I'll take their recommendation. I'll just pay the $2,000 if they can give me 12 months to pay it off. And if I pay it off early, if my probation would be terminated.
Now comes the hammer. The judge moves swiftly to shut the whole charade down. He informs the defendant that the hearing will proceed, with or without his cooperation. The courtroom energy shifts from confusion to control. This is the power of legal authority in full effect. Sovereign citizen logic just evaporated under real-world law. It's a quiet but powerful moment where truth overrides noise, and the system reclaims its ground. And just like that, the game is over. The judge pushes forward, brushing off the circus and handling court business like a pro. The Kai. Defendant's outbursts are ignored now. His moment has passed. What started as a courtroom hijack attempt ended in a lesson. Courts don't bend to fiction. That gavel hit different today. If you made it this far, make sure to like this video. Subscribe to the channel, and we'll see you in the next video.